Good morning, everyone. On behalf of the School of Law of the University of Chile and with a partnership with the Chamber of Commerce of Santiago, I would like to welcome you all today. Before I give the chance to talk to the rest of the team that is here today, I would like to say some words on behalf of the Dean of the School of Law, Professor Pablo Ristagli, that wanted to be here this morning, but unfortunately he could not be here because of other important compromises that he could not reject. We are delighted to welcome the first edition of this postgraduate diploma in national and commercial international arbitration. This is a cooperation between both institutions that I have already mentioned, and we are very pleased to start this new academic challenge together between institutions that are both public and private. So for this first edition, we have a number of specialists all over the world that will be here with us sharing during this semester. And because we have a very important guest this morning, I would like, before the introduction for her, I would like to present my colleague and co-director of this postgraduate program, Mrs. Macarena Letelier, who is also a graduate from our School of Law, and she also did an LLM, and she is also actually the executive director of the Chamber of Commerce and in this diploma. So please, Macarena, I am very happy that you can introduce the professor and that we can start today our first lecture. Thank you very much.
Thank you very much, Ana Maria. Welcome, Patricia. It's a pleasure for us having you here today. Ana Maria, she kindly present myself, but I'd like to tell some words about her too, because she's the head of the International Department at the Universidad de Chile in the Faculty of Law. And she has made a lot of work making bridge between international institutions and our faculty. And thanks for that, Ana Maria, and thanks you and your team because you trust in us in making this partnership. So today we are beginning this first postgraduate diploma on national and international arbitration. And just to tell Patricia some words about our institution, let me tell you that the Universidad de Chile was founded in the year 1842. The University of Chile is the main and oldest institution of higher education in Chile. My university, our university. And is one of the most prestigious in Latin America, being a national and public higher education institution which assumes with commitment and vocation of excellence the training of people and the contribution to the spiritual and material development of the nation, building leadership in the innovation development of science, technologies, humanities, arts, through in function of teachings, creations, and outreach with special emphasis on research and graduate studies. In the other way, the Santiago Arbitration and Mediation Center, called CAM Santiago, is turned in a non-profit institution established in the year 1982. This year, we are celebrating our 30 years, Patricia. With more than 5,000 cases between arbitration and mediation that have been managed by the CAM Santiago institution, has become the Chile leading dispute resolution organization and one of the most important arbitrations here in the region. Our postgraduate diploma on national and international arbitration, the only one of this kind in our country, will be taught through the Zoom platform. From today we have our first class with Ana Maria this afternoon. And its general objective is for students to acquire knowledge about the theory and practice of arbitration along with world-leading academics and practitioners. And now let me tell you all that are joining us today, who is our guest, Patricia Shaughnessy. I hope that's okay, the pronunciation, Patricia? Well, Patricia is going to inaugurate the first edition of this postgraduate diploma of national and international arbitration, and we are honored to have you here today with us. Patricia is a fully turned associate professor at Stockholm University Law Department, where she has been teaching and researching international procedural and commercial law with a specialization in arbitration for nearly 30 years. Prior to her academic career, she was a practicing lawyer focused on civil litigation and commercial law for 10 years in Hawaii, Patricia. Wow. She consults an expert as an arbitrator too, leads legal development projects, contributes to training programs, and frequently lectures at other universities, as we have her here today. Patricia got her LLM in International Comparative Law and her PhD at Stockholm University, where she has the founder and director of the Master of International Commercial Arbitration Law program between 2000 and 2018. Currently, she's member of the International Chamber of Commerce, ICC, Court of Arbitration, institution that we represent to here, Patricia, with the National Committee, and international board member of the Tehran Regional Arbitration Center. Previously, she has been vice chair and board member of the Arbitration Institute of the Stockholm Chamber of Commerce, government appointed expert on Committee on Revision to the Swedish Arbitration Act, and board member of the Stockholm Center for Commercial Law. Thank you very much, Patricia, for being with us today and for having accepted our invitation. Now the floor is yours.
Thank you very, very much for your very kind introduction. And it's indeed a great pleasure and an honor for me to be with you here today, having the inaugural lecture of the inaugural diploma course. So I'm really excited to have this opportunity to launch what I'm sure is going to be an exciting course, and hopefully it's going to be the first edition in a long tradition. But it will take you a long number of years to get up to the tradition of the university, which has been established for so many hundreds of years. Let me just start. I always tell my students when I'm training them for advocacy and giving presentations, never start with an apology, ever. But I will do that. The rules are meant to be broken. I had a wonderful week last week at the Paris Arbitration Week, which was a number of large conferences and events and about 40 different seminars and dinners and cocktails. And after that wonderful week, I came home and woke up Saturday morning with some serious COVID symptoms. So I've spent the last 3 days in bed basically, but I didn't want to cancel this opportunity. So if I start having a coughing fit or need, as you can hear, my voice is a little scratchy, I'll be drinking tea. And if I end up having a coffee fit or starting to sneeze, I'm going to quickly go on mute and I'll quickly turn my video off. Don't despair, I'll be back in a minute. So I apologize for that in advance. Let me also say, as a professor, I truly believe the most important learning tool and that we have is the question. So the questions are what help us to creatively find new answers and to explore more deeply and to engage in critical thought. And I understand that all of you are postgraduates and that all of you would not be taking this course if you were not interested in exploring what are the issues and what are the different solutions. And it will be really boring if you have to listen to my scratchy voice for the next hour and a half almost. So I really welcome interventions. I welcome you to ask a question, to make a comment, to challenge me. I do not have the monopoly on knowledge, and we'll be exploring some issues that may be controversial. So it would be welcome to be interrupted at any time. Or you can post a question in the chat or the Q&A, and I'll try to keep an eye on that as well. So with that, I'm going to do something that I don't like, because I prefer discussion and interaction over my just transferring knowledge. And I call PowerPointless. But given the fact that we're on Zoom and we're getting started with a broad topic, I'm going to also break that rule, and going to start with screen sharing to a PowerPoint. So I hope that all of you can now see this, and I will get it started with this. So are we on? Good. So we're going to be talking today about the past, present, and future of international commercial arbitration. And as I'm sure all of you have probably observed in recent years, the way in which movies and even indeed books and other works of literary arts are done today, they very seldom start from a starting point of the past and work their way forward. They tend to suddenly drop you into a scene, and you're trying to discover, where am I? What are we doing here? And then it kind of moves you back and it moves you forward. And somehow near the end of the film, you start to see how everything is falling together, or how the book is together. So we're going to do that a bit today. So if you're looking for a very chronological or very lineal discussion, you may be a bit disappointed, but hopefully it will help lead to a mosaic of understanding. But we will have some semblance of organization here, so fear not. So let's start with how I envision this lecture, which I hope will become a discussion. So as I said, we're not going to start necessarily at the very ancient past. Before we go off on looking back to where we once were, I suggest a quick snapshot of where we are today. It's usually easier to look over our shoulder if we first are aware of where we are at today, and then can move into exploring that with the benefits of the hindsight and where we may be going tomorrow. So after taking a quick snapshot of today, we'll look back, and we'll start with a very brief comment on the ancient practice of arbitration. I understand from your reading materials that you have an introductory material that gives you a quick snapshot of the ancient practice. And then we'll go into key milestones in the development of arbitration as we are at to today. We'll look at the recent past. We'll also look at developing theories of international arbitration and why they matter, because we will see that those theories are developing out of the past. They've taken us to today, and they're bound to evolve into the future. And that will then take us back to kind of where we start, taking stock of the present. Where are we at in this field today? And that will help us to start to see if we can identify future trends and potential risks. And then going into the predictions about where the future might be taking us and leading to some conclusions. So with that, I will then now go to the start of, where am I? Why isn't it changing? Why isn't my slide changing? There we go. So here, looking at international commercial arbitration today, let's start by just taking stock of what we mean by arbitration. And as your introductory materials briefly touched upon, let's ensure that we are all on the same page when it comes to what arbitration is and how it is differentiated from other important dispute resolution processes. And I can note already now that this is going to become more important than ever when we get to where we are today and where we're going in the future, because as we will see, the future of arbitration has really evolved into providing increasingly distinct tools that can be used to achieve efficient, effective, and fair dispute resolution, which responds to the needs of the users of arbitration and the commercial objectives that they seek to obtain by going to private dispute resolution. And so in order to understand how these different tools work discreetly, independently, and also when they start to get mixed together, then we need to be sure that we're all on the same page as understanding that these are very distinct processes which bring to them very specific expertise and procedures. So if we start with mediation, then I assume that everyone is familiar with mediation, so I'm probably stating the obvious, but I will to ensure that we all have a common starting point here. Mediation is a process by which a neutral facilitator assists the parties in trying to find an agreed upon solution to the dispute that they have. And a trained mediator has learned skills to help the parties to be able to identify what are the things that really matter to them in the dispute. What are the issues that are really key to resolving the dispute? What are the things that are not so important? And what are the things that they feel they need to achieve? And being able to find common ground to reach a compromise. Mediation is very much a forward-looking process. It looks towards trying to move on past the dispute, hopefully perhaps even preserving the relationship between the parties, which could result in continued business. It's quite different than arbitration, because arbitration is a backward-looking matter. There is no concern about whether or not the parties could manage to find a solution that they can live with. The arbitrators are not tasked in helping them to find a compromise. The arbitrators are tasked with deciding the issues the parties have brought before them. The arbitrators have an adjudicative function to decide the issues presented to them based upon the contract and based upon the applicable law, and not based on any ideas of fairness or equitable resolution. It's strictly based upon what has happened in the past and how that should be decided in the context of the applicable law and the contract that the parties have presented in the context of the submissions of the parties, of course. I sometimes say that it's a bad example, perhaps. If I, when my children were smaller, had left them at home alone when I went to go shopping, and they were aware of the rules, and I come home and find out they've been playing ball in the living room and have broken a vase, then if I was in a mediating mom mood, I would probably ask them, what happened and what role did you play? And how can we fix this vase? And what can be the way that we can get it cleaned up? Maybe it can get repaired or not. Maybe you can contribute to buying a new one. How are we going to move forward from this? If I'm an arbitrating mom, I'm going to come home and start pointing fingers and saying, you knew what the rules were. Who broke the rules? Who threw the ball first? Who's going to pay for this? Who is going to be penalized? And so it's a very different process as an arbitrator to make the tough adjudicative decisions that will be imposed upon the parties. And it will be a matter of assigning who has breached, who has acted commercially reasonable, who has a legally accepted excuse, etc. So that's quite an important distinction. And we will come back to that when we discuss the modern trend of mixing and matching these different types of dispute resolution. Negotiation is different. Negotiation, you'll see that quite a lot in arbitration clauses or dispute clauses, that the parties shall first try to amicably resolve disputes, or the parties shall enter into negotiations. Sometimes the negotiations are very informal, and sometimes the dispute mechanism can provide for very structured negotiations. between high-level people within the companies. And the negotiations, just like mediation, may or may not resolve in a final resolution of the dispute. That's why it is quite important, if one has a mediation and negotiation clause, that it is combined with a final and binding adjudication in the event that the negotiation or mediation are not successful. And that would be typically arbitration or litigation. And of course, we know that arbitration varies and is distinct from litigation because of the private nature, rather than being a state-supported body that is providing the administration of justice. Now, neutral evaluation is increasingly common. We sometimes see that parties may bring in a neutral, and one can note also that in the context of mediation, we have evaluative mediation and we have facilitative mediation. A neutral evaluation is to have someone who is an expert, somebody who can come in, can review the positions of the parties and give their objective evaluation of what they think the respective likelihood of success of this potential outcomes for the parties that can maybe help the parties to resolve the dispute. Expert determination has become increasingly popular today. And expert determination is when an expert in the particular area, it could be commodities, it could be a highly technical dispute involving intellectual property, it could be expert determination regarding very technical matters in construction, it could be in engineering, it could be any number of things. And the expert will then reach a determination that could be binding or non-binding, depending on the party's agreement, as to what the outcome should be. And if it becomes a binding determination, then that would be the end of the dispute. However, if the parties do not agree to carry out the determination, it could not be enforced under the arbitration regulatory framework because it's not arbitration. You would be at a breach of contract result by not following the agreed upon expert determination. I can pause here to show you one trend for the future. As I promised you, this is if it is a mosaic. A couple months ago, the Stockholm Arbitration Institute, the SEC, launched something called the SEC Express, which is a new variation of expert determination. And last week at the ICC Commission meeting at the Paris Arbitration Days, there were discussions about expert determination as becoming something that perhaps arbitral institutions need to expand and promote more. I think people were thinking perhaps to some degree the SEC Express, and the SEC Express provides for a set amount. Parties can subject their dispute to an expert determination that will be reached within 3 weeks. It can be binding or not binding, and gives them an opportunity to, in 3 weeks, get a determination on the outcome of the dispute. And this can complement an arbitration or not. Dispute boards arose and became quite popular, also called dispute adjudication boards, or in the FIDIC contracts, they're called now dispute avoidance and adjudication boards, also known as DABs. These dispute boards became, as I said, common in the context of construction and infrastructure projects, which are long-term large contracts, so that the board can either be set up at the start of a contract or when disputes start to arise. And the board typically consists of an accountant, a lawyer, and an engineer. If the board is used in a different context, it may have different members. And the disputes are brought to the board, and the board decides the dispute while the project continues in real time. And I won't go into detail other than to mention that once the board's decision is made, there's an 87-day under the FIDIC contracts, but they can be different. Dispute boards rules can vary substantially, and we're seeing them come into many arbitration institutes. But there's usually a period for filing a notice of dissatisfaction. And depending upon the contract, you may be prevented from going to arbitration until you have completed these steps, or may be considered a matter of admissibility. So we will come back to that, because this has been an area which, when you start to mix these things, can create issues about when one has the right to commence arbitration. And finally, I'll just mention adjudication, popular and big in construction and infrastructure projects in the UK and in Australia, starting to pop up in other places. It is a adjudicative body that's not expert determination or arbitration, and it's come up in those contexts. And the important thing to note is that the processes are somewhat different, and it is not arbitration. So if you get an adjudicated decision, it may not be enforced under the New York Convention, which is applicable to arbitration. So let me also note the distinction between commercial arbitration and investment arbitration. Your materials that you had for the lecture today makes this distinction.
Sorry to interrupt you, but the slides are not running. Just to, I don't know if you noticed that. Maybe you have to turn off and begin again.
Okay.
Sorry, but I prefer you to know.
Yeah, no, good to know. We try again. Can you see it now?
Yeah, that's perfect. Thank you very much.
Now it's perfect. And then if you need any help for the moving, you can let us know and the team will help you.
Thank you. Maybe I've infected my laptop with my COVID. So there's a distinction between commercial arbitration and investment arbitration, which was in your reading materials. And that's quite important today. Commercial arbitration involves, of course, commercial disputes between businesses. One should also make a distinction with consumer disputes. In some regulatory frameworks, such as in the United States under the Federal Arbitration Act, they are regulated under the same regulatory framework, which causes all kinds of difficulties in trying to accommodate very different interests of business, commercial disputes, and commercial. Investment disputes are, as the materials that you read point out, when an investor from one state makes an investment in the host state and considers that the host state, the state of the investment, has violated the treaty rights or expropriation through not giving full security or other matters, and wants to bring a claim without going to the national court of the host country. And under these literally thousands of bilateral investment treaties and multilateral treaties, that has been for years that the mechanism for resolving those disputes has been arbitration. Those of you who've been following this may be aware that Chile has faced in the last year or two a few new investment disputes, and as have countries around the world. The reason why I bring this up is we will come into what's happening today. And as we look at the future, we're seeing that right now, the UNCITRAL Working Group 3 is working very much on the reform of investment arbitration, also known as Interstate Dispute Settlement, ISDS. And this has also been going on significantly within the European Union in its new treaties. And I know that Chile has been negotiating a new treaty with the EU, and the EU is trying to replace arbitration with multilateral or bilateral permanent court solutions or temporary court solutions. So we won't go into that more now, but one of the important things in making that distinction is they will be subject to different regulatory frameworks, although the procedure of arbitration has been relatively similar. And very important, there are many concerns that the reform of investment arbitration and some of the things that are happening may end up affecting commercial arbitration in some ways. And so we will come back to that. And we'll also see that increasingly in the context of commercial arbitration, we're starting to see some public interests which come into play. And then there is this tension between having public interests being decided in the context of a commercial arbitration, where the parties are representing private rights in a private proceeding. So the distinction between public and private, commercial arbitration, investment arbitration, are posing challenges that we'll all be facing today and going forward. Let me also make a distinction, which I'm sad to say, I wish I had knew more, and I hope to learn more about the Chile arbitration environment. But in many places of the world, there remains an important distinction between domestic arbitration and international arbitration, and that they may be treated under different regulatory frameworks and subject to some different procedures and different judicial review and such. And so that's something that one should be aware of, particularly if one is venturing into arbitrating in a different environment with a different seat of arbitration. I can mention that one of the regions that I've worked on in the past, and I'm currently doing a couple of projects currently in the former Soviet Union space, you have in a number of these environments, and even in the Baltics and such, a distinction between the way domestic arbitration and international arbitration is practiced and is regulated. And so it's important to know if you get involved in arbitration in those environments. And lastly, again, I don't know in Chile, but in some environments, such as in the US, generated from the 2001 Federal Act requiring that all federal courts have some kind of ADR or arbitration, and many state courts doing similar. There are many state and federal courts that have court-annexed arbitration or mediation programs, so that if you file a civil case in the court, or even family law cases and such, but even civil commercial cases, that you may be required to first try arbitration or first try mediation. And the arbitration sometimes is non-binding, and sometimes it's quasi-binding. And we're not talking today about these court annex programs, which are one step in what's called the open door of the courthouse to provide different forms for resolving disputes. We're talking about today with consensual arbitration, where the parties agree to arbitrate, thereby foregoing their right to go to court. So let me see now here we go. So if we go to the foundation of arbitration today, coming out of the history of the past, we have the idea of party autonomy as truly the foundation of arbitration. And when we talk about party autonomy, this is a point in a live lecture. I would definitely turn off my PowerPoint and try to engage everyone in discussing it. Then we say, where does it come from? Where does it exist? Is it some general principle of the law? Is it some natural law? Where does it come from? And it's interesting because it's ascribed to the freedom of contract. Commercial parties are given the freedom to enter into contracts. They can decide the price, quality of the goods, the delivery, a number of things. And just as they can do that, they're also free to decide for a mechanism to resolve the disputes. If they have a dispute, they're free to agree on a settlement. They're free to make a new contract to go forward with, to amend the contract or replace it. And there are any number of ways in which the parties are able to express their freedom of contract. And one of them is to enter into an arbitration agreement concerning their private commercial matters, where they delegate the ability to decide over the dispute to the arbitrators. And one of the interesting things about party autonomy that makes it so fascinating, as I said, I have the privilege sometimes to contribute as a consulting expert to legal development projects. And in that role, I've been teaching and helping policymakers and legislators and such to develop the arbitration regulatory framework and practice and development. And I've done that in some countries where freedom of contract is not particularly well established. For example, not any longer, not in the last few years, but prior to that, several times I've been working in the sphere of developing arbitration in North Korea. Now, I think everyone recognizes North Korea is not a country which has a robust freedom of contract and commercial arbitration, yet it does engage through its state-owned entities in, despite sanctions, or in places where the sanctions don't apply in buying and selling and trading goods and services. And we see in other countries that back in the pre-market economy days of the Soviet Union, back in the 60s and the 70s, there were state-owned entities in the former Soviet Union doing trade with American companies and European companies and many companies. So we see many places in the world that have not had a market economy, have not had freedom of contract, but yet are willing to accept the concept of arbitration. And that is because arbitration has become a key way to enable trade. And so that when the state-owned entities are acting in a commercial context, they need to have a way to be able to resolve disputes, or it'll be very difficult to enter into any kind of agreements for the buying and selling or trading of commercial goods or services. This principle of party autonomy underlies many of the key regulatory instruments in trade law and in arbitration. And the principle of party autonomy enables the parties to be able to choose the applicable law. It enables the parties the freedom to determine the procedures, to agree on the arbitral institute, the seat of arbitration, and most arbitral institution rules, as well as arbitration laws, provide in many respects that the parties are free to deviate from the default provision. For example, unless the parties agree otherwise, there shall be 3 arbitrators. Unless the parties agree otherwise, the arbitrators may do X, Y, Z. The concept of party autonomy also allows the parties to choose arbitrators, which has been considered an important characteristic and right and leads to the legitimacy of arbitration, although we'll see in current times and moving into the future, that has been a right which has been under some scrutiny and some recommendations that the right of party-appointed arbitrators should be limited. It's also the freedom to settle the dispute. Even after a dispute is brought to arbitration, the parties own the dispute, it's their dispute, and if they want to settle the dispute and to terminate the arbitration, they have a right to do so. The arbitrators and the arbitration institute and the seat of arbitration has no individual or specific interest in the dispute continuing. However, when it comes to all the exercises of this freedom of party autonomy, all of these things are subject to mandatory provisions of the applicable law and to certain restraints to protect important public policy. So, for example, although the parties may choose the applicable law, they cannot choose to contract away mandatory law that must be applied. They cannot choose to determine procedures that would deprive one of the parties of essential due process rights. They cannot choose arbitrators who are not impartial and who are not independent. They cannot choose to settle the dispute and ask it to be put into an award on agreed terms if that consent award or award on agreed terms is actually a maneuver to try to engage in money laundering or corruption. So we can find exceptions to the party autonomy. There are some limits to party autonomy. And indeed, this topic has generated extensive academic writings and interesting practical cases. If we go to the key characteristics of arbitration, again, party autonomy, it's the foundation, and it is a key characteristic, and one of the things that makes arbitration so attractive. The agreement to arbitrate is an essential characteristic of arbitration. The right of the parties to enter into an agreement to arbitration and to be able to fashion it to the particular needs of their case and what they think will be the best way and the best place to arbitrate the dispute. Now, caution here, in your coming lectures, I'm sure you're going to get lots of information and discussions about ways in which the agreement to arbitrate can be made a huge dispute in itself through poor drafting, putting provisions in which cannot actually be operable, and creating other kinds of issues. But the basic concept is the parties are free to fashion an agreement to arbitrate. Another key characteristic is the neutrality of the forum, and of course, the neutrality of the arbitrators, so that when there are two parties who are entering into a commercial transaction, neither party may find it comfortable to have to resolve a dispute in the national courts of the opposing party, particularly since litigating in a national court will mean having to not use your own lawyers usually, but having to get lawyers in that country. It'll mean having to litigate in a foreign language, to litigate under foreign court procedures, to litigate in what might be considered an unfriendly forum. And consequently, arbitration offers the opportunity to find a neutral forum where neither party may be perceived as having an advantage. Again, we've already talked about the choice of arbitrators, that the parties can choose arbitrators that they think are particularly suitable for the case, whether that be on their experience, the technical know-how, the commercial issues, etc. And also the flexible procedure. The arbitration regulatory framework leaves lots of room for flexible procedures to adapt the procedures to the particular needs of the case and the parties, and to achieve the most efficient, effective, and fair result. As we will see today, there's great importance placed on efficiency and effectiveness. And arbitration is striving to become more efficient and more flexible to ensure that the procedure is adapted to the particular dispute. And a really important key characteristic of arbitration, which also makes it so popular, is that it will end the dispute in a binding and final award, which can be enforced, as we will see in 169 countries around the world. And this binding and final nature of the award, which is often called the principle of finality, is a key aspect of arbitration. So briefly, if we just take a quick look of the advantages of arbitration, again, efficiency, finding efficient solutions. In most places, arbitration will be much quicker than going to a national court. In Stockholm, for example, if we go to the district court with a commercial dispute, it doesn't get any priority. Priority is given to cases involving children, criminals, etc. And so in Sweden, which is known to have a very highly functional judiciary, a regular commercial dispute could take 2, 3, or maybe even more years in the district court, and then you would have another 2 or 3 years, maybe at the Court of Appeal. At the Stockholm Arbitration Institute, most cases from the time the tribunal is constituted to award are achieved within a year. many less, and then there's some outliers longer. And if one uses expedited arbitration, which has become, as we'll see when we come to the modern view, very popular, then we see even more efficiency. As we'll see, arbitration struggles to be cost effective. Arbitration usually involves having a lot of lawyers, and the more lawyers, the more legal technicalities and procedural matters, and the more expensive it becomes. But there are lots of efforts to try to reduce these costs, and we're monitoring by the arbitral institutions. And again, we'll come back to that. The advantage of arbitration is its flexibility and procedural tools, that they're not as rigid as national procedural codes for courts. The parties' control over the case. Importantly, confidentiality, although as a little note here, one should be careful about that, because whether or not there is confidentiality inherent to arbitration varies around the globe. In the UK, yes. In other countries, maybe not. In some countries like Sweden, no. If you want confidentiality, it may need to be a specific agreement between the parties, although arbitration institutions' rules generally impose confidentiality on the institution and the arbitrators. But you need to be careful when choosing rules and seats of arbitration if confidentiality is important to you, and you may need to make a special agreement. Enforceability is a huge advantage of arbitration. No other dispute resolution mechanism can boast of the enforceability that arbitration has. That doesn't mean it's often easily done. Sometimes there are skirmishes in court proceedings where it is resisted, but it's generally the most preferred way to get enforceability. Again, neutrality, and as I mentioned, the ability to have commercial and technical expertise rather than going to a general judge in a state court. So are there disadvantages? Of course. There are reasons why some disputes may be better suited for courts. For example, in some areas, the parties may prefer a court solution. For example, if it is a matter that's going to be a very summary, a small matter, a summary procedure could be available on getting the discharge of a certain monetary amount, like a particular payment, then they may find the national courts are more suited, particularly if the contracting party is still there. There may sometimes be issues about the limited powers of arbitrators. Arbitrators are just ordinary people like all of us on this Zoom today. Just ordinary people like you might meet when you're in the grocery store tonight. Often lawyers, but under most laws, they're not required to be. But what gives them their special powers is when the parties appoint them as arbitrators and they're constituted as a tribunal. And suddenly they have more power than a state court judge. They can make a final award that will be binding on 169 jurisdictions in the world. But the power is limited to the parties to the arbitration agreement. To anyone other than the parties to the arbitration agreement, these arbitrators have no more powers than the person sitting next to you on the subway. And so if there are third parties, which a party may want to bring into the arbitration or to have the arbitrators make orders against, then there may be limitations on the arbitrator's ability to do that. However, modern arbitrations, now we're moving into modern again, the modern arbitration rules generally provide for joinder and consolidation of non-signatory parties. But these usually require that the party who is not a signatory to the arbitration agreement is considered to be bound to the arbitration agreement by different theories, which you will be exploring in your course and we'll touch briefly on later this morning or afternoon. And that is that the parties have acted in a way in which they are found to be actual parties to the arbitration agreement. Under some rules, a party could be bound anyway if all the parties, including that party, agreed that this party should join the arbitration, because then it would be like a new arbitration agreement, including this party. But that's something to consider, because that may be an issue in some contexts that parties may want to be aware of. And also that the powers of arbitrators, when I have the pleasure of coming back and talking to you about interim measures, we'll find that the powers to issue interim measures, of course, are limited to the parties. And again, as I said, cost was an advantage of arbitration, but many today contend that arbitration is getting as expensive as litigation. So it is the responsibility of all of us in the arbitration community to try to ensure that arbitration lives up to its promise of cost effectiveness. Although the concept is that a party who agrees to arbitrate has an obligation to arbitrate, sometimes recalcitrant respondents may seek to start court proceedings in their own or another jurisdiction. So one can end up with parallel court proceedings despite the agreement to arbitrate. And then that can rise into some complications and additional costs and such. But one could say that that can happen with court proceedings as well, because unless you're in a environment where you have a regional treaty or convention which provides for judicial recognition of other judicial proceedings, such as the Brussels regulation in the EU, then you would have difficulty stopping parallel proceedings. Of course, for those familiar with common law jurisdictions, particularly the UK, there are anti-suit injunctions to try to stop them, but they sometimes appear in arbitration. And then again, the idea of arbitration is that you won't go to a court. And indeed, it's estimated that about 90% of all cases, they go through arbitration, and then the arbitration award comes and the other party, the losing party, pays, and that's the end of it. But there are a significant number of cases which go to challenge and enforcement issues, which we will be exploring in the course. So to finish up on our snapshot, we now have wide acceptance of arbitration. The fact that I was in Paris last week attending conferences with over 300 people from not only in Paris, but from around the world, attending more than 40 events, goes to show how arbitration has become such a widely accepted practice area. We have 169 signatories to the New York Convention that we'll touch upon in a bit. The UNCITRAL model law, depending how you count, has about 75 jurisdictions which have implemented it as its national law. And it has influenced the arbitration laws of many countries which have not actually adopted it, such as the UK Act of 1996, which is being reviewed and may end up becoming model law, the Swedish Arbitration Act, the Swiss Arbitration Act, and others. And we have 164 signatories to the Washington Convention, which is the investment arbitration under ICSID. Many studies have showed that arbitration has actually become the preferred way for businesses to resolve disputes in cross-border contexts. And if we look at the growth in arbitral institutions, the number of institutions across the world today, and the number of cases that they're managing, then we can see there's definitely a big growth in arbitration practice. Law firms' growth and arbitration practices have grown. Today in many places in the world, if one asks about the contentious dispute practice of arbitration firms that have more substantial practices, they'll say at least 50% of their disputes go to arbitration today. And that can vary upon the environment, of course. Academic courses, such as this, programs in arbitration, and the expanding regulation, guidance, commentary, and scholarship all shows that arbitration has achieved wide acceptance. So with that snapshot of where we're at today, let's take a quick look to where we came from. Where did this start with? So as noted in your reading materials, most places, Nordic countries, Greek, Roman times, if you go back to places like Kyrgyzstan, you can go around the world. And I would bet maybe even in your region of the world, you can find reports that go back to things which seem to be similar to arbitration already to ancient times, already to tribal times. And that so that there were the beginnings of arbitration, the idea of having two disputing parties, having their dispute resolved by selected wise or respected members of the community. They were all usually men back then, has existed for some time. And there are some, and I commend you to read the history. It's quite interesting. And then we can see from your materials that the Alabama case got a lot of attention for the success of arbitration. And there are, I can commend to you, if you're interested in the Alabama case and you want to read more, Johnny Wieder, one of the legendary profiles in international arbitration, who unfortunately passed away a couple of years ago, wrote a great chapter on the Alabama arbitration, a lot of inside information in a book published by Oxford called the Arbitration Virtues. If you're interested in that, I can put it in the chat. So we see that arbitration started to gain more modern usage already in the late 1800s. A significant thing happened in 1899, and that's the Permanent Court of Arbitration at The Hague was established by treaty. And it's an intergovernmental organization designed to resolve international disputes. Now, it's usually thought, the PCA has traditionally been kind of thought as state to state, and you probably have seen some of the big cases. There's some cases that have been live streamed, such as from the PCA in recent times that one may go back and look at. But increasingly, the Permanent Court of Arbitration is resolving commercial disputes between parties and has developed rules for human rights issues to be resolved in arbitration. You may be familiar with the Bangladesh arbitration as one, if you're interested in historical and in important big arbitrations. That is one to take a look at. That was done as a result of the Bangladesh fires and that caused the death of many workers. So, but today the Permanent Court of Arbitration has really taken on a more modern approach. And if any of you are interested in the Vis Moot or have done the Vis Moot, I don't know if it's been, I don't think I'm revealing anything confidential, but the next year's moot problem will be based on the rules of the PCA. So you can start to get yourself familiar because, as you know, in the Vis Moot, it has to be something involving the CISG. So it's going to have a commercial aspect. So the next thing that happened, of course, after 1899 and leading to the next thing on the slide is World War I. And World War I, of course, devastated Europe, and it dragged in, of course, other countries as well, the US, Canada, others. And it was a devastating, and it tumbled a lot of longstanding empires and kingdoms, and it, as you saw in your reading materials, started the Merchant of Peace. And the concept Merchant of Peace, when I was at the ICC conference on Monday and the commission meeting on Tuesday, I noticed people were using that term quite often. We as merchants of peace must ensure, and I think one of the reasons that maybe have come back suddenly into using it frequently is because of the great concern of the disruptions going on in our world today and the need to try to ensure the concepts by which the Permanent Court of Arbitration, the ICC and such were founded as a way to avoid the tragedies that we're seeing around the world. Now, as you know from your reading materials, the Merchants of Peace were a group of industrialists and commercial parties who decided to band together and start the International Chamber of Commerce. And it was founded on the concept that it would provide opportunities and try to promote commercial activities across borders. And that through doing that, by enhancing and facilitating cross-border trade, that it could help rebuild Europe and importantly, rebuild confidence and rebuild prosperity and rebuild peace by having the formerly warring parties engaged in commercial activity, which helped to build relationships and trust and build prosperity and peace. And today, the ICC, the message it's really getting out under the head of the ICC, John Denton, and the new from July 1, ICC Court of Arbitration President Claudia Solomon, they really are on pushing and really articulating that their originating mission is very much their mission today. Today, they may have 45 million members, commercial parties across the globe as members, but their mission today, as it was in 1919, is to serve the business community to enable it to do business. And in 1923, the ICC Court of Arbitration was created because it was recognized that despite all the efforts to facilitate business through different instruments and different activities, that if there wasn't a way in which to resolve disputes, then it would be kind of like an ink pen with no ink. You could sign the contract would not be worth anything if it could not be enforced. So in order to put ink into the signing of obligations, to put ink in that pen, there needed to be an enforceable mechanism for resolving disputes. And that was the ICC Court of Arbitration. And indeed, it has been now resolving disputes for almost 100 years. And it has a very important and broad standing. But today there are literally hundreds of other arbitral institutions. And happily, you have a very established, credible, and experienced one in your own jurisdiction. And so they're all contributing to the same concept of enabling businesses to resolve their disputes. Now, as I think it's very important that arbitration institutes, which are connected with chambers of commerce, they have a very clear mission that they're serving businesses, that they see their job not as trying to make money or not as trying to, nobody is celebrating there are disputes. They want to avoid disputes and help businesses to resolve them quickly, efficiently, inexpensively, and get back to business because they're serving business. And I can say that as an aside because in some environments, notably in the Baltics is just one example, but I can give you other examples that are closer to your home, but I won't name them, where some arbitration institutes were developed as profit-making activities, not business service activities. And this usually is a downward spiral to disaster because the arbitration institute needs to be a neutral body who's devoted to serving its users, not to just devoted to making money. And so it becomes, and of course, by making money, the institution can reinvest and ensure the competence of its secretariat, ensure the quality of its services, the technical solutions. So of course, having the institution being able to be self-sustaining and being able to always be staying on top and developing itself is important. But it really is, for the integrity of the system, important that the main mission is to serve businesses. So having made that spiel, you can hear I feel strongly about that. We then go from 1923. It's not surprising, this is the same year, it was the ICC. The ideas were going at the same time. In order to make arbitration agreements and outcomes enforceable, in order to make it work, they needed a international instrument that would make that happen. And that was the 1923 Geneva Protocol on arbitration clauses in commercial matters. And that worked pretty good, but then it was thought that it needed to be not a protocol, but a convention, and to be given a little bit more structure. So in 1927, it was upgraded to a convention on the execution of foreign arbitral awards. So that ensured the enforcement of the outcomes of arbitration. The ICC started to later, particularly after the Second World War, encouraging the creation of a New York Convention. Once again, we had a very disruptive, very horrific war that caused all kinds of disruptions and needs for rebuilding. And it was thought that creating a new convention would help ensure that arbitration could provide a way to facilitate business and help to rebuild after the war. So it's rather amazing. If one looks at the New York Convention today, you can be very critical. Indeed, people have been very critical that it's the drafting. I mean, any one of you could draft a better convention today. But if you think about it, it got drafted primarily at the 3-week conference held in New York, attended by 45 states in the spring of 1958. And in 3 weeks, they hammered out the New York Convention. And it wasn't until near the end of the work that somebody realized, oh, you know, this would actually work better if we also enforced arbitration agreements. Because if we don't enforce the arbitration agreement, we might not ever get to an award. So then, although the convention is called the New York Convention on the Enforcement of Foreign International Commercial Arbitration Awards, we find in Article 2, it also enforces agreements. So despite the fact that it's not been drafted very well, it's generally thought that if it ain't broke, don't fix it, and trying to negotiate a new one with 169 members would be a very difficult exercise. So I'm not going to give you a lecture on the New York Convention. That'll be coming to you much later, but just be aware it is the backbone of the international framework for international arbitration. And when we talk in a minute about the different theories of arbitration, this has a key role to play. And it created this efficient, effective pro-arbitration mechanism. And again, 169 countries are signatories. And the primary obligations is that courts, the primary one again, was the recognition of foreign arbitral awards, subject only to very limited and exclusive exceptions. And then it was added to courts to recognize the validity of arbitration agreements, subject to limited exceptions. And then third and importantly, it requires courts to refer parties to arbitration when they have entered into a valid arbitration agreement that is subject to the New York Convention. So this was a big step forward from the Geneva Convention. Lastly, on our historical tour, I want to mention that UNCITRAL, the United Nations Commission on International Trade Law, which I am pleased to be have been working with in a number of ways over the years, it has had a huge impact on not just international trade law, but on arbitration. And it has created some of the main instruments that we have. And it was created in 1966 as a UN commission. And as one can see, the idea of it is to ensure that obstacles to the flow of trade could be removed. And the idea is that by removing these obstacles, we will increase prosperity. It will give more opportunities for everyone, and that will also lead to more peace. So you can see the mandate is for the progressive harmonization and unification of trade law, including arbitration. And the composition are 60 members that are selected, and they rotate. And all of you may recognize that your own Chilean arbitration expert, Andreas Jana, has been the head of working group 2, which deals with arbitration and mediation instruments for UNCITRAL. And he's been doing a great job leading that work over the last couple of years. Oh, now what I want to do is to end the slide share and jump into a discussion now of where we are at today and where we may be going. And again, I recommend interrupt me at any time.
Professor, if you find it appropriate, there is a question for you from the public. So if you like, I can read the question for you, and you can start maybe from that idea, the discussion and all the ideas that you would like to add to your presentation.
Yeah, why don't you go ahead and...
I will, yes. What would you say are the major concerns regarding the proposal currently being discussed at UNCITRAL WG3 to establish a permanent court to resolve investor states disputes in replacement of the existing investor state arbitration system? And a second question together with this one, are there any risks of that proposal that the public should keep in mind? Please, you have the floor.
It's an excellent question and a really big question and a controversial question. And there's a lot of work going on, and there are many who think the movement towards creating a multilateral court is troublesome. And one of the main problems, which is pointed out, is who are going to be the judges and who are going to appoint them. And will investors have any opportunity to be part of that, or will it only be the states? And in one of the original on the EU list that they launched some time ago about potential court members, they were almost all academics without any practical experience, and academics that were more involved in constitutional law and international law than in arbitration and such. So that's one issue. And another issue is who's going to pay for this? Institutions need buildings, and they need staff, and they need maintenance, and they need software. And so there are a lot of different issues. That's just a couple. But many are of the opinion that the states are concerned about the way that arbitration has been done. Some will tell you that concern is overstated or not justified. Others will say it is. And at the end of the day, it's up to states who enter into treaties to decide what they want to do, regardless of what commercial parties that are making investments want to do. But one of the things which is very much affecting this right now, the current things that have been discussed most recently, is also the code of conduct for adjudicators. And this code of conduct, when they say adjudicators, because if it becomes a court, then they will be judges. If it remains in the context of arbitration, they'll be arbitrators. And it's now been revised a bit, but many consider that it may spill over and start to affect the way in which one considers whether a arbitrator in a commercial case has a potential conflict or not, and that many consider that the code of conduct, which is being discussed in the context of Working Group 3, is not well suited. Particularly, it's also a bit rigorous on having expressed opinions in academic writings and such, or having served, having decided issues that are generally similar in another arbitration. So that's gotten a lot of attention and discussion. And on the other hand, these discussions are giving us a great opportunity to take a look at what we've been doing and where we should be going, and what reforms may be good, and what are the costs and what are the benefits. But I really can't unpack that more than that today, but I'm happy to hear that some of you are watching it, and it's definitely an important space to follow.
Thank you very much, Professor. And I don't know if somebody else would have a question that would like to write for the professor today, or we can continue maybe with the discussion of today. So we are open. Oh yes, here it comes another. In the article, ICC Conciliation, a glimpse into history, Stewart Hamilton stated that if we look back to the early 1920s, when a scheme for resolving international business disputes was first discussed by ICC, we find that conciliation, far from being overshadowed by arbitration, was conceived as its equal, and in practice was the more prominent of the two services. What role do you think mediation will have in the coming years?
Much bigger role. In many environments, mediation has been very slow to get started. We need more success stories, and we need people to try it more. But we're seeing that it's becoming more popular, and the fact that UNCITRAL created the Singapore Convention on the Enforcement of international commercial mediation settlements, and that convention, which provides an enforcement mechanism, can be a great boost to mediation in a number of ways. And importantly, we're seeing now that it's become quite common. Before there we had this what we called mediation arbitration, med-arb, or escalation clauses, and those still exist, but they sometimes create problems about when you can, and when the mediation has started and ended, and when you can go on to arbitration, and if it's jurisdictional or admissibility. And I'm sure you'll discuss that. But what's come up more recently and is gaining a lot of ground is what's called med-arb, so that the arbitration gets started, and then there is a planned window at the outset or at the time that the parties agree on to go into mediation. And then if it doesn't settle, then you continue with arbitration. And that is gaining. It's also known as mixed mode dispute resolution. And we're also seeing quite a lot of movement, which is contrary to a common law tradition and culture, but has existed in the civil law culture, such as in Germany, China, etc. And that is that arbitrators are being encouraged, or even under some approaches, must encourage settlement at an early stage, and have, already in the first case management conference and in the materials, that they need to be suggesting to the parties that they should try to settle, asking if in the CMC if there should be windows for settlement discussions, and maybe even asking that the parties accompany the lawyer to early case management conferences, so the parties are actually there to be able to discuss things. But one must be careful, because the arbitrators are going to be ultimately, if the case doesn't settle, deciding. So they need to be careful that they do not compromise their independence and impartiality, that they do not seem to be making preformed decisions about the case before they've heard everything. So one needs to be a little careful about that role in changing hats. I wrote an article a few years ago in a book honoring a Kai Holber, international arbitrator from Sweden, called The Renaissance Arbitrator, the multitasking role. And in that, the concept of the article was that today's modern arbitrator needs to be able to function in a wide variety of tasks as a settlement facilitator, as able to deal with good case management. You have to be aware of data protection, cybersecurity issues. You need to be able to adapt to the efficiency needs, technical issues, etc. And that's both good news and bad news. I think it's great news, because now I'm kind of going back to the past and jumping to the present and to the future. What I think is really important. In the past, the people who were arbitrators generally came from North America and from Northern Europe, and they were men and they were older and they had long and honorable careers, often not only as lawyers, but maybe as diplomats or other kinds of internationalists. They spoke foreign languages. And so they were this kind of revered, esteemed. And so this group then became the arbitrators in cases, and they became this elite group. And it was difficult to get into that group. The barriers to entry were quite high unless you worked as a secretary for many years at the knee of one of the elitists that brought you up. So you still see a group that are getting a large chunk of the arbitrations and have deserved esteemed eminent reputations and a great deal of experience. But as arbitration has spread around the world with new users, new providers, a whole new world of parties practicing and seeking solutions from arbitration, as well as the rest of the tools in the toolbox. We need to ensure that the providers of arbitration services reflect the world of arbitration. The users, they come in all ages, shapes, forms, religions, genders, regions, nationalities, backgrounds, and we need to ensure that what our service providers are reflecting that, and that they can have in the pool of arbitration and of arbitrators and mediators and expert determination has expanded so that there is a wide variety of competent people who have the skills and the experience to be able to arbitrate. And it's not reasonable to say, you may not arbitrate your first case until you've already arbitrated 10 cases. Obviously, that doesn't work. And so there are ways for young arbitrators to get experience that make them competent to be able to step in. And we all need to contribute to fostering the widened pool of arbitrators, to ensuring diversity, to ensuring that we retain legitimacy and that our arbitration community reflects the values of the users that we're serving. So
thank you very much, Professor. It has been a so interesting conference this morning to inaugurate this program. And I also would like to ask you, due to the time also, and that because we kept, everybody was still here, listen to you. I have maybe one question before we close this morning. So what would you say that the economic sanctions have hindered partly autonomy? And if so, how?
Yeah, it's an excellent question. And last week in Paris, Doug Jones, an eminent arbitrator, made a speech on that at the GAR construction that was recently reported. And Jackie, the Secretary General of the London Court of International Arbitration, has spoken on this. It's an issue because we need to ensure the rule of law, and the rule of law ensures that people are able to have lawyers representing them. When Russia launched the war on Ukraine in 2014, when it invaded Crimea, and then when it started to support the fighting in the Donbass region, there were arbitrations going on about the taking of property, about commercial activities, about buying and selling of gas and energy. And so there was a distinction between that. The new sanctions now have made it very difficult. And so we're starting to see lawyers leaving, resigning from their positions of representing in the cases. We've seen problems in sanctions before with Iran and some of the challenges that face. And then we're also seeing that arbitrators may feel like they need to resign, particularly if there's not going to be any payments that are able to be made. I think this is something we all need to really think long and hard about. I think we all want to be on the side of deterring and sanctioning unprovoked aggression. But on the other hand, we are all as lawyers on the side of the rule of law and ensuring the right of representation. I can't answer that in this short time, but I think it's something that's all of us need to be responsible for and to be thinking about and coming up with, what are the solutions which are value driven, that relate to the values that we hold dear and that will actually contribute to the rule of law.
Thank you very much, Patricia. And now I will give to Macarena the floor to give maybe the last words to close today this inauguration. Please, Macarena, go ahead.
Ana Maria, thank you very much, Patricia, for your words today. Just I'd like to highlight what you said about the party control in this mechanism. I think that is the face of freedom, and is the way that we look for justice sometimes. And choosing the arbitrators is very special because we trust in these systems. So we are going to work with the system, with the centers, with the truth in some way. So I take that point of the advantage of the arbitration and mediation, the freedom, the party control. So with this, I would like to thank you all the ones that joined today, this seminary, just because it's the beginning of our postgraduate diploma. So see you this afternoon with Ana Maria. I think that is 8 o'clock, Ana Maria? No, 6 o'clock.
It's 6 o'clock, but because it would be 18, so that's why you said
18.
It's 6 hours or 18 hours.
Yes. So thank you very much again, Patricia, and I hope to see you soon.
Yes. Thank you. It's been such an honor. And I'm really already looking forward to Interim Measures with all of you.
Thank you very much, Patricia, and see you all this afternoon. Bye-bye. Thank you for joining us. Have a great day. Bye.